So you have the floor, sir.
Beaucoup.
Thank you very much indeed. We're delighted to have been invited here to present to you our study on the exception for the presentation of this data and text. Now, our activities are pretty much international, and our colleagues will speak in English. So I would also like to switch to English just to keep the flow. Sorry to tell you that.
Mention it. If you need any advice or during the plenaries and you have some doubts or questions, we're just round the corner. Just give us a call and we'll be happy to come and assist. Before we enter basically in the... Trying to switch this, but does not work. Can you... Yeah, thank you. So before we enter into the technical issues, because text and data mining is quite technical, even for lawyers, maybe a few words to relocate the subject in a broader picture, and also to highlight the major challenges that might be useful to know if you're not a copyright expert. So just a few words about the copyright objectives. Copyright is there to incentivize creativity. We want to protect creators. But it has also a bigger purpose. It's to secure broad access to copyrighted work for EU citizens and also to enhance cultural diversity. This is what we call the social function of copyright law. We do that because we want to make sure that the EU is a great environment for creativity and innovation, and that's why we need copyright law. In order to do this, we need two things. We need to have protection, and we need to have access. And these are the two sides of the same coin, and these always need to be secured. And to be very clear and quick, I think we do quite good on the protection side. We have exclusive rights that are defined in broad terms in the Copyright Directive, and they can quite easily adapt to technical changes. The Court of Justice is there to interpret it and did quite well in order to incorporate all the new digital uses. But on the... can you switch, please? On the limitation side, we're not doing so well. Our Copyright Directive from 2001, by the way, in 2001, text and data mining was like science fiction. So our Copyright Directive from 2001 is basically setting up a list of restrictive, limited exceptions, which are all optional. So that means that member states can pick and choose whatever they want. And so at the end, we don't have any harmonization on the limitation side, and we don't have any flexibility. Most of these exception limitations in 2001 were drafted with having the analog world in mind. So, but the problem here is that exception limitations have a key role for dissemination of knowledge and in order to create free spaces for future creativity, in particularly for boosting research in the European environment. And then not only doing this, they're also, for most of them, incorporating fundamental values of the European Union, which are ranking at the very top of the hierarchy of norms in the Charter of Fundamental Rights, such as freedom of expression, freedom of information, freedom of art and science. And they bind the legislator, that means us today, and they bind also the judiciary. Next slide, please. So what is the consequence? The consequence is that we urgently need a reform on the exception limitation side to adapt them to the digital environment. And the Commission has been trying to do this since ages. First, a green paper in 2008, and it's almost becoming very boring as a copyright expert. I feel like since 15 years I'm repeating every time the same story because nothing has changed since then. And in 2008, exception limitation were the highest on the agenda of the Commission, and it took many years to reach here. Though now the time is there. If I take the objective of the European copyright reform as formulated by the Commission, we need better access to digital content, and we need a modern, more European copyright framework, and we need to have a cross-border online activity for having a true digital market. So these are the stakes, and here it's a little bit of a historical moment that we should not let pass. Next slide, please. So it seems to me we have an urgent need in the field of text and data mining. In the analog world, text and data mining was not an issue. We know that facts and data and copyright law are not protected. And when I was doing my PhD, I went to the library, looked into the books, made photocopies, and with a pencil, I underlined the important passages. That was text and data mining in the analog world. In the digital world, I'm doing searches, keyword searches, and it goes much faster. And there's a greater potential to use this to boost research. The problem is all these acts basically have implication when it comes to copyright. There are reproductions. There are reproductions also for neighboring rights. My colleague, Professor Rosati, mentioned databases. So there are lots of different technical reproductions here. Next slides, please. So when you look into, of course, the existing law, you look into the catalog of the copyright directive, and you have a whole list that of exception limitation that tackle a small part of the issue. I listed them there. They are really discussed in length in our paper that we have given, so you can look them up. Temporary acts of reproduction, research exemption, normal use for databases, also the private copy. But none of them is really addressing the picture overall. So this leads for researcher to a big legal uncertainty, in particular because we have a very unharmonized framework. There are a couple of countries that have these exceptions. UK was mentioned, but there are others. So far, we need to be now very brave on this. So this is the only message that, from a law professor, I would have to you. This is a clear issue. No hesitation, please. Give the word to my colleague to address the different national implementations.
Next slide, please. So in the absence of legal certainty, some of the member states went ahead and adopted exceptions or limitations for the purpose of text and data mining. So the United Kingdom in 2014 was the first of the member states to adopt an exception. So exception was limited for for research purposes, non-commercial use, when users have lawful access. The exception was not applied to databases. Then, in 2016, France adopted its exception for text and data mining. Again, it was limited to lawful sources for non-commercial use, and it was limited only to text and data contained or associated with scientific writings. It was also extended to databases, to copyrighted works, and it also covered the communication and storing of processed text and data for the purpose of verification and ensuring quality of research. In 2017, so 1st January 2017, exception for text and data mining entered into force in Estonia. This exception is extended to any persons for non-commercial purposes, but it requires attribution of the sources that served for this text and data mining. This made the exception rather difficult to implement. 1st March of this year, 2018, the exception for text and data mining will enter into force in Germany. This exception it covers works as also databases. Use of databases is qualified as a normal use explicitly by the German Copyright Act. It extends to non-commercial purposes, and again, like in France, the communication and storing of text and data processed for the purpose of text and data mining is permitted for the purposes of verification and quality assurance of research. Without making this overview exhaustive, there are some further legislative discussions in some other member states. And the message here is essentially that without this problem being tackled on the European level, there is increased fragmentation as all of those exceptions on text and data mining already implemented in the national legislation of some of the member states are different in their scope. So there is already implications for cross-border exchanges and research cooperation in the EU. It's needless to remind that actually many of the European grants for research cooperation in Europe, condition for them is a cross-border cooperation between research institutions in different countries. CEPI being one of such organizations in Strasbourg that cooperates with other partners in 4 other member states of the European Union. Next slide, please. So few main legal characteristics of the research proposal, of the proposal proposed by the European Commission. So first, it has a mandatory character, this provision. All member states will have to implement it. Secondly, there is a protection against contractual override of this provision. Thirdly, there is some protection against the technical override of this provision. With regard to the scope, next slide, please. With regard to the scope of the text and data mining exception, so it permits, the Commission's proposal permits reproductions of copyrighted works and extractions from databases. With regard to beneficiaries, beneficiaries are limited only to research organizations which are non-purpose or which activities of which are limited to public mission, to public interest mission. Private-public partnership is permitted only to a certain extent. Conditions. These beneficiaries, so research organizations, should have lawful access for the purposes of scientific research. So this is the main requirement to those organizations. Next slide, please. So with regard to implications, so the first implication is, so this proposal would achieve a level of harmonization, as all member states would have to implement this exception. It would also facilitate cross-border text and data mining activities. So researchers situated in different member states are sure that the same exception is applied in the different member states. Thirdly, it would bridge the regulatory gap with regard to the innovation-driven jurisdictions such as United States, Canada, Japan, Israel, some of which adopted, like Japan adopted a specific text and data mining exception extended also to other users. Then, protection of text and data mining exception against contractual and some technical override will also ensure that effects of the legal norm is not negated by dominant private actors. That is, the purposes defined by the legislators are not overridden by private actors. Text and data mining exception will not prevent, and this is very important, next slide please, very important point, text and data mining exception does not prevent right holders, so the owners, the makers of databases, from continuing monetizing their databases, their resources, for selling licensing access to them as they do it today. So reading those articles or downloading any other publications as we do it today will continue to be possible. Then the text and data mining exception will not change anything. This is also a very important point. It will not change anything for journalists, innovation-driven startups, for public authorities, for example, authorities investigating when there are famous cases of leaked materials and where would public authorities investigate cases of corruption or transparency, public authorities would not be able to use text data mining. So it doesn't change, at the same time, it doesn't change anything for other categories. So only research organizations are concerned today. Thank you. And now I leave it to my colleague.
Very much. Good morning. This is Giancarlo Frosio from CEP as well, and I will try to wrap up as briefly as possible. Okay, just give me a couple of minutes, and on the overall assessment for this proposal, and we think that the assessment is positive on the Texan data mining section in general. It will bring harmonization. It will bring about legal certainty for researchers, and it will then take us closer to the promotion of a digital single market, which is the fundamental goals of the reform we are talking about. And then, therefore, for this reason, will take Europe, will improve the innovation processes in Europe. However, there is room for improvement here. Mainly because the scope of the exception could be broadened. And this is very important, not to be left behind by other jurisdictions and this race over the endless sea of information and data. As you might know, we produce 3 quintillion of bytes of data per year. In the last 10 years, we created more data than the rest of human history, and Texan data mining is the compass to navigate this endless sea. Now, how we make this possible? First, I'll be super fast, with intervention to improve the text under consideration. Next slide, please. And there's a number of proposals in our paper related to fix a number of textual technicalities which should broaden the scope. Next slide, please, and I will move through this. Next slide. But then, more important, the scope of the beneficiary should be expanded, possibly dropping the limitation to research institution, or at least expanding the scope to more beneficiary, like journalists, for example. And again, expanding the scope by enabling story and communication of research results, because one of the key points of text and data mining is to be able to verify those results. Next slide, please. And again, the second very important point on the intervention could be done now on the text under review is an extension of the protection against contractual and technological override. First, to works and subject matter non-protected by copyright or neighboring rights. My colleague, Professor Rosati, mentioned the Ryanair decision that goes exactly in the opposite direction. And extending those contractual and technological override to other Texan data mining relevant exceptions. And finally, to conclude, next slide, please. This is also an opportunity to do something extremely important, to start a debate about an opening clause in Europe. This will really make Europe leapfrog other jurisdictions. An opening clause that is based on a number of factors similar, close to the so-called fair use clauses in the United States and other jurisdictions, could be based on a 3-step test, and it will be fundamental in order to make our system more flexible and more adaptable to technological innovation. A fair use clause of this type, an opening clause of this type, is what made possible projects like Ingram, project able to text and data mine the entire corpus of literature in the history of humankind, and then create a service that lets you find patterns of words throughout history, how much we have used a word throughout history. An opening clause will be capable, allowing a number of companies, private companies, European startups as well, to do this job for the European community. And I'll conclude here, and I'm very sorry that we took a few minutes more. Thank you very much.
Merci infiniment.
Thank you very much indeed for your comments. I'm going to give the floor to colleagues in a moment, but prior to that, I'm going to ask whether the Commission wants to take the floor, Mr. Geiger. Just 5 minutes, please. Yes, thank you very much.
Shorter than 5 minutes, I think. Just I'm very happy to be here. This is an important part of our copyright modernization proposals. I think that the scope of what we have proposed and the objective have been quite well described by the speakers who spoke before me, so I really don't need to go much more into detail. Just recalling that with the Commission proposal we have wanted to ensure full legal certainty for text and data mining carried out by research organizations. So we really tried to focus specifically in the area of research because this is where we saw most evidence of problems in the debate over the last years, and when targeting research organizations like universities, research institutes, we wanted to have as clear as possible a legal framework. This is why, as speakers who introduced the topic before me have explained, we have decided to propose an exception which is not overridden by contracts. We have put check and balances from the point of view of the application of technical protection measures. And importantly, I think we have gone beyond, in these regards, the current research exceptions in the 2001 directive because we have not limited the exception to non-commercial purposes as it was the case in 2001. We have rather confined the actors, so research organizations, which would benefit from the exception. Now, generally speaking, we have seen that the proposal has been received well by the Council and by the Parliament. I think nobody is really challenging the objective and the intention behind. Now, of course, we've been discussing this for 1 year and a half, so we're actually coming quite close to the moment where a final deliberation will have to be taken both in the Parliament and in the Council. The debate at the moment, at least, maybe in the Council we have seen texts already, a bit more advanced going in this direction, but I'm sure that, this committee is also working intensively on that in the Parliament. The debate at the moment is whether the range of beneficiaries should be extended as compared to the Commission proposal. And on that, I think that there is an important aspect that I want to highlight, which is the fact that, by focusing specifically on the main players of public research, somehow, we have also wanted to, at the same time, as I said, focus on the area where there was most evidence of the problem, but also acknowledge the fact that in a purely commercial sector, there are licensing which are being concluded, and there is a market, at least in some areas like pharmaceutical, chemicals, and so on. So somehow I think that when trying to find, a final balance, it would be important for all players to take into account areas where there are functioning market mechanisms, where there are licensing which are in place, and areas where these may actually not be the case or may not be desirable. And in this respect, I think that, as I'm sure that some of the speakers which will intervene after me will say, there is a discussion which has been opened somehow in the Council about the status of text and data mining on content which is freely available online, which I think Eleonora Rosati touched upon at some point earlier. And there I think the issue is that there are a number of data analytics activities which are actually being carried out at the moment in a sort of gray zone, because they may or may not be covered by copyright protection depending on whether there is copyright protected content, database or not. And I think this is something which is a debate which we are seeing, and I think it's important to have, but keeping in mind the balance that we needed to find in this discussion. Thanks a lot.
Je vous remercie beaucoup de votre intervention.
Thank you very much for your intervention. We'll now move on to comments from members. We'll begin with Mrs. Rader and then Mrs. Geringer. And I will be inviting our guests to then respond and conclude if there are no other speakers among members who want to take the floor. Mrs. Rader, please.
Much for the very interesting briefings and presentations. This is a question both to you as researchers but also to the European Commission, because you have mentioned journalists and the use of text and data mining in the media. I think we can all agree that journalists or newspapers are not research organizations. They're generally private companies that do text and data mining, however. This morning we had a discussion with a participant of the Commission's high-level working group on fake news, which is a startup that uses text and data mining in order to track fake news and to debunk them. And Dr. Rosati, you have mentioned that if the neighboring right for press publishers is passed, it's very clear that a journalist who does text and data mining would also have to get a license for the mining of news articles, even for parts of it that are not protected by copyright. So I am wondering, since the Commission was saying that there exist licensing solutions for commercial players, who exactly would the journalist have to get a license from in order to be able to mine fake news articles? I mean, would they have, these are quite often illegal or criminal organizations that are creating the fake news. And I find it difficult to imagine how a journalist would be able to get a license in order to be able to carry out their mission of debunking fake news. Thank you.
Madame Geringer, je vous prie.
Mrs. Geringer, please.
Ja też chciałam podziękować za Państwa prezentację. Dam Wam troszkę czasu do założenia.
Thank you very much. I'll just give you a moment so you can put your headphones on. Okay. Now this is a highly interesting debate, but unfortunately the rapporteur dealing with this file is not here. Now I am a shadow on this, as is Mrs. Rader, and I just want to say that what you say is very interesting. Now, we've discussed this issue before, and every time we discuss it, when we talk about harmonizing exceptions, it's like opening up some kind of Pandora's box. I mean, it seems harmonization seems so impossible that it almost seems not worth trying. On the other hand, however, there are also positive examples. There are other areas where we didn't think we could achieve any kind of harmonization, but we did eventually manage to deal with the matters in hand. So, for example, when it comes to copyright, then you have orphan works, and then eventually perhaps sometimes you do find the author and you can just carry on. Now there are people in this room who are perhaps less interested in achieving harmonization, but anyway, that's as it may be. But I have a different question. I mean, in this area, can you actually talk about copies, as is the case in other areas? I mean, a copy today is not the same thing as a copy 50 years ago. And then when you share a copy, it's not the same as how you did it 50 years ago. We're living in a completely different world nowadays. So, I mean, all these rights were introduced in the 60s or whatever, but actually they were dealing with completely different situations, different things. I mean, it's a personal opinion, but I think it's valid. I think we need actually a completely new approach because we've got very different objectives nowadays. I mean, in the old days, you used to sit down and write things down, perhaps by hand. I mean, people used to copy out books. It was a completely different world. So I'd be interested to know whether you've reflected on that and whether it's something you discuss in the scientific community or wherever. Thank you.
Très bien, je vous remercie.
Thank you very much. Mr. Rosati and Mr. Geiger. Unless Mr. Geiger asks someone else to take the floor. Mrs. Rosati, to kick off, please.
I perfectly agree with your point, and then I shall address MEP Reda's comment. And indeed, the world in which we are living today is very different from what was the case 20 years ago, but also 5 years ago. So it is a very rapid, exponential change that we are living in. And as far as copyright is concerned, I'm not sure that all the time the interpretation provided of copyright concepts has always been in line with this change that we are seeing. And with regard to the concept of copy, for instance, unless the temporary copies exception in the InfoSoc directive, just to refer to a significant example, applies, we live in a situation in which the concept of copy is intended broadly. And in this sense, for instance, I'm thinking about the very broad interpretation of what qualifies as reproduction. No? So even a very small amount that is reproduced might qualify as a potentially infringing act. So I agree with this point. And in relation to the comment of MEP Reda, indeed there might be a situation in which the makers and those that put in circulation fake news might be protected by intellectual property rights. So that might be a potential conflictual situation, and prompts indeed a discussion whether the idea of having such a narrow catalogue of beneficiaries is indeed the correct approach. And in this sense, I would like also to refer to the impact assessment of the European Commission, in which, if I'm not mistaken, the Commission highlighted how Texan data mining is perceived as a nascent tool in many sectors, in particular in research sectors, while instead its potential seems to be more put to use in business sectors. And by business, of course, I might refer also to journalism. So in this sense, if there is something that is being undertaken already, why should that be trumped or restricted? And to conclude, I think that the reference to the United Kingdom experience might be useful because also at the point of the discussion in the United Kingdom, there was the issue of who the beneficiaries of the exception would be. And the government, yes, was made aware that there is a licensing market for businesses in this sector, but came to the conclusion that even if licenses are in place, in certain issues it is so difficult to secure a license, permission needs to be obtained from so many different right holders, and here I'm quoting the government document. It was concluded that this might be an insurmountable obstacle preventing a potentially significant quantity of research from taking place at all. So I think that that is a point that arises from a national experience, but might be also of use in this particular context, also because it is a discussion that did not take place too long time ago. The exception was introduced in 2014, so it is somewhat of a comparable environment to what we are seeing today. And with that, I would like to conclude. Thank you.
Merci.
Merci, Madame. Monsieur Geiger.
Thank you very much, Mr. Geiger.
Monsieur Cavana. So very short, 2 points. in our paper, that was basically will also be available to you. It has not been distributed. I just saw, but it will be available. We indeed advocate for broadening the scope of the beneficiaries, just because we are a little bit uncomfortable with the fact that to say that outside research organization there is the licensing scheme and this license scheme is functioning. I would be wondering if there has been a clear assessment about this, because as Professor Rosati has mentioned, text and data mining involves to get licenses for copyright users, for neighboring right users, for database users, for privacy users, you know, like the right for privacy, etc., etc. This makes the licensing scheme extremely complex. And what we need to make sure today is that we don't create an exception that would be outdated in a minute. And basically, you know how much time it takes to revise the directive. We still want to have a vibrant creative environment here in Europe, and not be in 2 years with basically regretting that we are so tied up with this limitation. So maybe I think we should be a bit more brave here. One thing that might be considered, if it's for certain commercial users, there's always the mechanism that we know about providing a remuneration. So maybe this would be a compromise solution if you are opening up the list of beneficiaries. We know that, for example, for press reviews are classically unremunerated exception. If you allow businesses to do electronic press review for companies, then a right for remuneration come into place. So this might be something to look into. And with regard to the fact that a copy nowadays has nothing to do with a copy in the past, it's true. Nowadays we do a lot of copies that we don't even know there are copies. For example, we surf on the internet. There are some copies in your computer that are made, and it's nothing to do with you know, going to a photocopying machine and getting an article. They are just technical copies, but that these copies in some ways qualify as reproduction within the framework of copyright law, and we need to make sure that all these copies that somewhere out there are not blocking anything at the end.
Je ne vois plus d'autres demandes d'intervention de...
I see no further requests for the floor from my colleagues, so on behalf of the committee I would like to thank you for your... please, Mrs. Ryder.
Thank you very much, Mr. Chair. Since we have a bit more time, I actually have 2 follow-up questions to what was just said. One thing is this idea that there might be a distinction between non-commercial and commercial, where commercial users would perhaps come with a compensation for the rights holders. To go back to my example about the journalist who is trying to analyze fake news, does that mean, I mean, it's a commercial actor, the journalist, would they then have to pay the authors of the fake news a compensation for being allowed to show that they are fake news, basically using text and data mining in order to debunk them? This would seem a bit unfair to me. I mean, I could understand perhaps a compensation in cases where we are dealing with some kind of professional copyright authors, but in text and data mining this is quite often not the case. I mean, we have seen examples of companies that use, for example, we had a breakfast this week where the example came up of trying to create an algorithm that can automatically detect pictures of a shoe. And you need to show this algorithm thousands of pictures of shoes in order to be able to learn and to recognize them. And these pictures are usually taken from the internet. The people who took the pictures are usually not professional photographers who are members of a collecting society. So if you try to distribute this compensation, wouldn't you have the same administrative burden that you have for getting a license? I mean, I could see how it would be easier in areas where there is a collecting society, but of course there are lots of areas where this is not the case. And the second question is relating to something that is being discussed in Council, which is that after the Texan data mining, the copies would have to be deleted. And what I'm wondering there is, I mean, on the one hand, from a practical point of view, what this would mean for the reproducibility of the results of TDM research. But aside from that, I think, wouldn't it also be a concept that is outside of copyright law? Because usually a copyright relevant act is either permitted or not permitted. So either you're allowed to make a copy or you're not allowed to make a copy. But I'm not aware of any cases where the reproduction is first allowed, and then after some time has passed, it is no longer allowed, except perhaps I mean, in the case of the temporary copy exception, it's a bit different because the copy in the first place is only allowed in transient systems. So I just wonder if this requirement to delete the copies really makes sense in the context of text and data mining. Thank you.
Deux réponses assez brèves, si vous permettez.
Two very quick responses, please.
First question about, so I mentioned the possibility of having a remuneration in case of broadening the scope. That does not mean it should address the question of journalists. I was more referring to, let's say we have tomorrow new businesses that emerge like data brokers who actually their profession is to data mine for companies a certain set of data to extract commercial value data that would be used for commercial purposes. I had this in mind maybe, you know, new startups, new business model. Journalists, no. This is clearly not what I had thought about, and maybe on the
if I may, and just remember that anyway, any type of compensation should be attached to the requirements of a three-step test. That's the idea. So we need to identify some sort of conflict with a normal exploitation or a reasonable prejudice of the interest. At that point, we can start, and in that scenario, that probably wouldn't happen. Another important point, 1 second. Regarding the reproduction, let's always remember that not all the data mining technique imply reproductions. There's a number of data mining technique, those based on so-called crawling, which would not even trigger the low threshold of the InfoPack decision. And we have no clarification here. This going back to that discourse about how the notion of copying has changed. We think there's copying there, but in fact technology does something different. And we need to adapt to that fast. That will be all.
If I can, add on that and the requirement of a compensation. If we look at the experience of private copying, for instance, the fair compensation requirement is linked to the existence of harm, no? So here I'm wondering, in the making of text and data mining activities, what is the actual harm suffered by right holders? Because what seems to be the case here is the fact that text and data mining is something that is not meant to create a competition, a substitution in the market for the original content, but it is rather about superseding the existing content in order to access aspects of it that are not protected by intellectual property rights, such as ideas, facts, etc., and use them in order to advance knowledge in a certain area. So in this sense, I'm not sure that there is an actual harm that would require compensation. And in addition to that, with regard to the possibility between distinguishing commercial and non-commercial uses, that might not always be a straightforward operation. And in this sense, allow me to refer to a different area of copyright, that is the right of communication to the public. If we are looking at how the Court of Justice has intended it in relation to linking, Now it seems that after the decision in GS Media, an important factor to consider is whether the link provider operates or not for profit. But it is not clear what for profit is to be intended. It is the link that is provided for profit, it is the link provider that operates in a for-profit environment. So I would think that if such distinction between commercial and non-commercial text and data mining is to be introduced, then one should be very careful in clarifying when there will be one scenario and another. And in relation to your second point about preventing the storage of copies, I see what the rationale might be, no? In order, that is, to prevent an undue exploitation of the content beyond the purpose of text and data mining. But perhaps the problem will not be really the storage as such, but the reuse of that storage for purposes that will go beyond the text and data mining activities. So I think that it is a slightly different point that, again, perhaps could be clarified if there is this rationale, which is, I would say, something to appreciate, but indeed clarity on this point will be welcome.
But actually, we have a solution here, which is the one already adopted by the German implementation of the, because here the problem is a verification of the result. So we can store the text and data mining results in some secure server at some institution, so that any scholar, any researcher can go back there in that secure environment and verify the result. So the solution is possible. The problem then would be perhaps that of communication to the public if somebody then want to communicate. But the storage of that can be done on a secure space and then verified there.
Au nom de tous mes collègues parlementaires et des...
On behalf of the committee and everyone present in the room, I'd like to thank both of the academic experts and their teams, and I'd like to thank them for their contributions and the information. I'd like to wish them well with their work, and I can't see anyone requesting the floor. I would imagine that everything is therefore settled, and I'd like to officially close today's jury meeting. Thank you and enjoy your lunch.